Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 205 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, the one-stop shop for all things FCPA compliance related. Today, you're in for a real treat because I have with me Jonathan Armstrong. Jonathan is a partner at Corderies Compliance in London. He's going to visit with us about the Schrems decision, which came down from the European Court of Justice last week. This is one of the most significant decisions around data privacy, personal privacy, online privacy, and many other issues. It has significant implications for anyone in the tech industry, but particularly for compliance practitioners in investigating matters out of Europe. The episode comes in at just under 24 minutes. I hope you enjoy it. Thank you very much.
Tom Fox, and welcome to this episode of the FCPA Compliance and Ethics Report. I am lucky enough to have Cordery partner Jonathan Armstrong on the line. Jonathan is actually in the United States this week. We both attended the SCCE 2015 Compliance and Ethics Institute. Jonathan is still in the States, so I asked him if he could take some time to visit with us on a subject that he is quite the expert on, and most of, certainly myself and most of my listeners are going to be very interested in, and that was the recent, as in this week, decision by the EU Court Advocate General around safe harbor privacy issues, and generally referred to as the Schrems case. So with that somewhat long-winded introduction, Jonathan, thank you for taking the time to visit with us.
Oh, my pleasure, Tom, and great to speak with you again.
So could you walk us through how this case got to the court before you kind of launch into what it means going forward?
Yeah, sure. There are actually a couple of pieces of litigation from Schrems, and he's an intriguing guy and a guy we've been following his litigation for a year or more now, probably about 18 months. So he has two main threads of litigation. The first is a class action against Facebook, saying that they have misused his data in part because they gave access, according to Schrems, to the NSA, to his Facebook data. And the second bunch of litigation is an original complaint to the Irish Data Protection Authorities, saying, in effect, that they had failed to supervise Facebook and, by proxy, the NSA. Now, the Irish Data Protection Authorities said initially that they didn't have, and I'm oversimplifying as I go, Tom, but they didn't have the ability to supervise that data transfer from Ireland to the US because the European Commission had made a decision saying that if people signed up to the safe harbor scheme, they were deemed adequate and that Facebook had signed up. It's important to remember that for the purposes of this call, the entity handling Schrems' data was a Facebook Irish entity, and Facebook say that the Irish entity transferred Schrems' details to the US, and then they may or may not have come within the NSA's bailiwick. What then happened is...
Cool. Could I ask you to explain what the safe harbor provision is, or perhaps was?
Yeah, so effectively this goes back to an original agreement that the EU or the Commission had with the US. So basically, under European data protection law, you're not allowed to transfer information to a country that isn't regarded as having adequate provisions, and the US is one of those, third world countries as far as data protection is concerned in the EU's eyes. And the way you can therefore legitimize transfer of data to the US is by having one of a number of special measures in place, and the biggest game in town was safe harbor. And safe harbor is effectively like a process that a business goes through. It certifies with the Department of Commerce. It is usually then subject to Federal Trade Commission supervision, and if it does that on an annual basis, it's deemed adequate. And so this decision was in place to try and help U.S. corporations and other multinationals with the data transfer issues. And the Irish authorities said they couldn't go behind this original decision that safe harbor was good. To cut a very long story short, Schrems disagreed. He took his case to the Irish court, and there's a well-established procedure in Europe that if the decision that the domestic court are being asked to look at concerns the law in Europe as a whole, European law, then it goes across to the court in Luxembourg, who look at that specific aspect and then send it back to the domestic court. So that's where we're at the moment. And to answer your introductory question, there are two significant bits now in that Luxembourg court's process. The first was Attorney General Bott, who last week gave a non-binding opinion on how he thought the court should decide, and this week the court more or less followed that opinion from Bott, and as a result we've had this monumentous decision this week. So that's
Jonathan,
summarizing a year and a half in 3 minutes. I hope that's not oversimplifying.
Jonathan, your firm has certainly been in the forefront of communicating about this case, talking about it, and after the decision came out, sort of immediately came out with information for companies, practitioners, general public, folks like me could have access to. And there's a couple of pieces from the firm's piece entitled European Court Rules Safe Harbor Invalidated in Schrems case that I'd like to ask you about, because I was frankly not aware of them. You give some advice to folks in the piece, and one of the things you talk about is putting in place a model form data transfer agreement. Could you tell us what that is and how a company might use that?
Yeah, sure. So as I said, safe harbor is just one of a number of different routes you can use to legitimize that data transfer from Europe to the US. One of the other options is using form agreements that the European Commission have put in place. Now, there are various agreements that apply. If you like, it's almost like a precedent book. You can take one out of the precedent book.
Wait a minute. What's a precedent book?
Right. So maybe you don't have the same in the US. In the UK, we have a book of form agreements that we call a precedent book that apply for various different purposes. So
we would call that the form book.
The form book. Then there we are. Then I've learned something else this week. So you'd use your form book. You'd pick the agreement that best suited the type of data transfer you were doing, and you'd sign up to that agreement. But here's the rub. It's not like a general form book agreement where you can make changes, you can cut and paste and move this section here, that section there. You're not allowed to correct the agreements at all, and I do mean correct. They have typographical errors in them. They're not well written. You take it or leave it. And that's the challenge for many businesses, because some of the agreements have contractual terms they wouldn't want to agree to, like joint and several liability for acts and things like that. So it's not a foregone conclusion that the EU model terms are the right route for you. It still needs careful thought.
Jonathan, in the same paper posted on the website, you also have a recommendation which starts out with consider moving to binding corporate rules. Could you explain what those are?
Yeah, so binding corporate rules are the sort of the new kid on the block, really, and have been a little bit sexy, a little bit up and coming, but not without their issues. I guess, if you like, the Justin Bieber of data transfer method.
That's the kiss of death.
And effectively, they've been promoted for a while as another option. And effectively, what they are is it's a It's an intra-company agreement to bind the company to say we will have these minimum standards of data privacy, a little bit like a code of conduct that the company agrees to be bound by. But there are a number of challenges. I mean, there's all sorts of debate as to whether legally in some jurisdictions they actually can exist at all as a matter of law. We have cases in the UK, for example, that says one board of directors is not competent to bind its successor. And again, there are issues. Initially, they were very, very expensive and high maintenance. Again, perhaps a bit like Justin Bieber. And they went, and to put a BCR in place, you went through a lot of money very quickly. Again, like Bieber, I'm liking my analogy as I'm going. I know one client that got through more than $1 million putting a BCR program in place. Now they're much more cost effective. There's a much more streamlined process. And effectively what you do is you take your document, once you've created it in your system, you go along to one regulator, you ask that regulator to bless it, and the theory is that he will then walk hand in hand with you to all of the other regulators in Europe and get them to repeat the blessing upon you. So the theory's great. It's where it's the practice that can be more challenging.
Jonathan, perhaps I could ask you to maybe step back and give the American audience who might be listening to this podcast some background as to why there's such a divergence in opinion about data protection from the European perspective vis-a-vis the American perspective. And I would certainly note, having an English wife, that you're English, you're not European, but you are relatively close to Europe, so that perhaps you could give us a little more insight into what's the basic difference of opinion here.
Yeah, I think it's fascinating. Basically, the people's attitude to data privacy across Europe are generally a reflection of the history of that country. So traditionally, data privacy law wasn't especially onerous when we originally adopted that as a European standard, because some of those countries that had more moderate views on data privacy, the UK included, held sway. But what we found is this alliance between, as an overgeneralization, Southern Europe and Eastern Europe, as the EU's expanded, that are very concerned about privacy issues. Why? Generally, because it's an inherited trait of their worry about a previously repressive regime. So whether that be Nazism, whether that be Franco, whether that be Mussolini, whether that be the former Soviet Union, they know that, I can give you no better illustration than when I spoke at a conference and the Latvian delegate said to me, "You will never understand how important data privacy is to me until your neighbor has been taken away and shot in the dead of night because of the information that the state got about him." So this is a heartfelt, hard-coded thought about data privacy, which will not change for generations. And for the US, I appreciate that's hard to understand for most, although obviously those who are from, some of those states, because the US is the world's greatest melting pot, do understand some of those historical events.
Jonathan, if I could turn the subject a little bit. In addition to both yourself and Cordry having quite an expertise in data privacy, you also have an expertise in compliance. It's broader than my remit of anti-corruption compliance. Nevertheless, you're well-versed in that. And I wanted to ask you, I see serious implications for U.S. companies complying with the FCPA, the Foreign Corrupt Practices Act, or perhaps the UK Bribery Act or other acts from this Schrems decision. And I was wondering from where you sit, do you see any issues for U.S. companies who may be involved in either internal investigations over allegations of bribery and corruption, or perhaps even more generally transaction or data monitoring that they would do as part of a best practices compliance program.
Yes, I do, yeah. Maybe I'll illustrate it by an example. So in my hypothetical case, let's say I'm a Houston-based oil company and I've got an agent out in Vienna who attends the OPEC pre-meetings, and I don't know, let's say I'm trying to get close to nation-state oil companies out at these meetings in Vienna, in my hypothetical. And so let's say I'm the oil company. I want to investigate that agent because I have a suspicion that he's been using some of his commission payments to fund, I don't know, nights out on in some a night at the opera followed by lap dancing around the ring or something like that. I've got concerns about this particular event.
Maybe even buy tickets to a Justin Bieber concert.
Exactly, yeah. Justin Bieber and dancing white stallions. What more could you want for a night out? And so I'm investigating this. Now, by previously I mean last week, probably the data relating to that investigation was going to come back to the US using Safe Harbor from my Austrian subsidiary, from their, let's say it's their computer networks. Let's say I'm looking at emails. I'm taking them off the Vienna server, transferring them to the US under Safe Harbor. Now, of course, if Safe Harbor's gone, what do I do instead? As I've said, there are various routes to legitimize the data transfer. So I could look at data transfer agreements. However, some data transfer agreements require prior approval from the Austrian data protection authorities. I don't know what the queue's like today, but in the past, sometimes that queue has been as long as 18 months. So can I suspend my investigation for 18 months whilst I get consent? The likely answer is not. So I probably can't do the DTA route, or at least I need to think it through. So what's next? I could look at these binding corporate rules that we've discussed. But then again, I'm going to have to find a lead regulator. There's probably going to be a queue around the hall because a lot of people are going in for BCRs. If I'm going to have to do that, I'm going to have to move quickly within a week or so. But even then, that process probably takes a year to 18 months, perhaps longer if there are queues in the various data protection authorities, which we can expect in a couple of weeks' time, certainly. So BCR is probably not an option. And then my other real option, I mean, I might be able to nuance things around and I might be able to look at it. But the other option that strikes you off the top of the head for most data transfers is consent. But can I really get consent in an internal investigation? Can I go along to speak to my Austrian agent and say, Peter, I just need you to sign this form to transfer your data to the US. Now, for consent to be valid, the European legislation, it has to be fully explained. It has to be honest. It can't be deceptive. So I've got to say to him, I want you to sign this form because I want to investigate you. I want to run a full FCPA investigation. You're the prime suspect. I want to take a look at your emails. And I have to inform you that, by the way, you have the right not to consent. And if you don't consent, there's no way I can investigate you. Could you sign the form, please? Now, what answer is he likely to give in an internal investigation? And how would the US authorities feel if I go and tip off the main suspect that he's under investigation? So it seems to me that areas like internal investigations are going to be truly, truly challenging. There are no hard and fast answers to this. And that's why, and I would say this, wouldn't I think any US firm that's doing an internal investigation, any US corporation that's doing an investigation, really needs to speak to Data Privacy Council who really know this stuff. And I don't mean, and forgive me for being really blunt, Tom, I don't mean Johnny-come-latelys who've picked up this case yesterday, read it, and are advising on it. Some of the client alerts out there are truly shocking, even from firms that should know better. It has to be somebody, and I would say this, wouldn't I, that's been doing it for 10, 15, 20 years, who knows their way around this. Why? Because you're going to get no sympathy from the bribery prosecutors, bribery regulators, if you mess this up. the SFO have already lost a case, allegedly, on the way in which the US firm involved conducted the investigations. They will have, rightly I think, no sympathy at all for people whose investigations are themselves conducted unlawfully. So it's going to need a lot of careful thought to structure data transfers, even to structure interviews. How do you move those interview notes about? How do you look at emails? All of this stuff is going to be absolutely critical, not only so that you don't break data privacy, data protection laws, but also tipping off laws, stamping, interfering with the scene of an investigation, etc., etc. All of these things are critical.
Jonathan, it really sounds like certainly at this point we have a lot more questions than we do answers, and that we're going to have to work through these really hand in hand with the regulators on both sides of the Atlantic.
I think that's absolutely right. I think we are going to have some sort of working measures in place. In some areas, I think there will be some leniency, but I think things like internal investigations are so critical, I can't see that there's much room for leniency from either the data regulators or the anti-corruption regulators.
And if we could just lay on as another layer of complexity in the September announcement by the Department of Justice in the form of the Yates memo, that they want companies to immediately, as in when their internal investigations begin, identify individuals who may be targets and immediately turn that information over on almost a real-time basis to the Department of Justice so that the Department of Justice can then prosecute individuals. I think you have a lot of very difficult questions to work and wade through going forward. So, Jonathan, unfortunately, we're near the end of our time, but if I could disclaim that my law firm, Tom Fox Law, will not be doing any data privacy consultations or advice, and with a lead into that perhaps your firm could, and if someone listening wanted to follow up with you, could they do so via email? And if so, how would they email you or otherwise contact you?
Yeah, sure. I'm always happy to talk to people about it. As you would expect, we're running a 24/7, 365 service for these sort of questions at the moment, and as long as we have energy, we'll keep that up. And you can reach us at www.corderycompliance.com. That's probably best. Our main switchboard is there. You can reach me, obviously, by the details of the website there, or at jonathan.armstrong@corderycompliance.com, and then the Cordery Twitter account at Cordery UK. Obviously, don't send confidential messages that way, but you can keep up to date with our updates on Twitter and our website and our films on the YouTube channel. And do get in touch, yeah.
And for those who've not looked at the Cordery website, I would encourage you to do so. It is just a fabulous website in terms of the information they provide. Several of Jonathan's partners also practice in this area, and they have put on interviews and provided other information in a wide variety of topics in addition to data privacy, and it will give you a really good sense of the need for a real expert in this area. So, Jonathan, thanks a lot for taking the time to visit with us, and I look forward to continuing the conversation.
My pleasure, Tom, and thanks so much for the invitation. Let's watch it together.
All right, cheers.
Take care.
Hello, everyone. This is Tom Fox again. I hope you enjoyed this episode of the FCPA Compliance and Ethics Report. I would like to remind you about my upcoming FCPA Masterclass in Seattle on October 26th and 27th. We're going to keep the registration down to 10 attendees, so it will be an excellent, very focused way for you to learn about best practices. If you have any questions about it, you can contact me at tfox@tfoxlaw.com. You can also check out information on my website, Advanced Compliance Solutions. I hope to see you there. Thank you very much for listening to this episode of the FCPA Compliance and Ethics Report.